Does legislation permit the civil court to hear a matter emanating from the criminal court? This was the question pondered on in President Cyril Ramaphosa's challenge of the private prosecution against him. Ramaphosa has turned to the civil court, arguing that his rights will be infringed upon if he is hauled before a criminal court on a process he says is constitutionally flawed. The full bench, however, raised the distinction of the two courts, which Judge Lebogang Modiba noted should not be overly simplified.
The issue he raises is about procedure. It's not about the type of court. It's more about procedure. And we well know that the procedure that is followed in the criminal court is very different from that followed in the motion court.
Yes.
What he is asserting is that the president, having been summoned, should have appeared in the criminal court, and only there may he challenge his title to prosecute when he pleads in terms of section 106 H. It is, right? H. That's his complaint.
Yes. Yes.
So
yes.
I think I'm of the view that the manner in which the court in Part A, the full court in Part A, as well as the judgments on which that court relies, oversimplifies this issue.
Advocate Nwako Maineji, SC, on behalf of the President, acknowledged this point, but further qualified that this still does not preclude President Ramaphosa from approaching the civil court if his rights are being infringed upon. He added that the legislation does not deem Ramaphosa's challenge to be wrong.
The whole jurisdiction is about power. It's about whether the legislation allows the civil court ever to find itself enjoying the power to determine a matter which emanates criminally. In other words, in this particular case and all of those cases that the court has looked at, where there is a clear violation of the CPA in terms of private prosecution, and I'm saying this because that's how you must assume for purpose of jurisdiction, does the legislation or the scheme of the legislation make it clear that the jurisdiction of the High Court to grant any relief is excluded when it comes to criminal matters? That is the hard question of jurisdiction.
Zuma's lawyers, however, maintain that the civil court lacks jurisdiction, adding that the civil matter is now ventilating issues which could be ventilated in the criminal court. The former president's lawyers add that the issue is also premature in terms of procedure.
We say that the applicant is in the wrong court for two separate reasons. The first being what my learned friend eloquently put out, in other words, literally the question of the forum. We are just in the wrong forum. But there's a more nuanced reason why they should not be here, which is the issue of prematurity. In other words, that even, and for that proposition, assume for a minute they were in the right court. Assume this was a criminal court and everyone was wearing red robes and so on. And by the way, I'll come to the issue of red robes. We are saying that even if this was the criminal court, it's premature because the statute that governs this type of proceedings says when the issue of title to prosecute should be raised. And it's very simple. Section 106 says it must be raised when the plea stage is reached. Has that stage been reached now? No.
Zuma is accusing Ramaphosa of being an accessory after the fact in the alleged disclosure of his health records in his corruption trial before the KZN High Court in Pietermaritzburg. He alleges that Ramaphosa failed to act on the alleged breach, which compromised the NPA and by extension the criminal justice system as a whole. The matter continues on Thursday. Canny Maphanga, SABC News, Johannesburg.